Tort reform. It's a term most Americans don't think much about, but corporations spend millions of dollars on this campaign to take away your legal rights so they can pad their profits. In Texas, tort reform has been brutal, destroying the rights of patients and workers. First, let's understand the term. As compared to a crime, a tort is a civil wrong that causes someone to be harmed or suffer loss. When someone hurts you, you're supposed to have the right to take them to court. Having your day in court is as fundamental an American right as the right to speak or worship freely. But all too often, tort reform prevents people from pursuing wrongdoers and holding them accountable. It isn't really reform properly understood. Instead, this decades-long corporate campaign guts and deforms our laws, turning them against working families. In our country, no one is supposed to be above or below the law. We believe in impartial and equal justice under the law. As John Adams said when fighting the evils of tyranny, we are a nation of laws, not of men. In Texas, the elite have elevated themselves above the law, granting themselves special privileges while denying equal protection of the law to the rest of us. So how do corporations and other elites bend the laws in their favor and use them against us? Primarily through political influence, pure and simple. For example, according to followthemoney.org, Texans for Lawsuit Reform, the main tort reform group in the state, has given over $54 million in political contributions over the last 25 years. That is an astonishing figure. And what have they gotten for all of that money? A series of legal restrictions that put you and your family at a disadvantage if someone harms you or an insurance company cheats you. In Texas, your life is, in large part, valued by the size of your paycheck. In many cases, you are essentially what you make, which is a cheap way to value a sacred life. If you're one of the 250,000 Americans who die of preventable medical errors each year, the value of your life is capped harshly in our state. Under tort reform, non-economic damages for pain, suffering, disfigurement, and impairment in medical malpractice cases are effectively limited to just $250,000. And although costs rise each year, Texas is just one of a handful of states where the dollar amount of the cap stays the same. There's no cost of living or inflation adjustment to the cap, meaning lives are effectively worth less and less each year, as the value of a dollar is worth less and less. Malpractice cases are very expensive to bring because they require experts whose time is valuable and costs a lot. By setting the cap on non-economic damages this low and keeping it there, many working and middle-class families who don't make enough in wages are prevented from bringing their legal claims for purely economic reasons, no matter how deserving their case is on the merits. The tort reformers claimed we had a crisis in the supply of doctors and sold these legal restrictions with claims that they would lead to more access to health care. University of Texas law professor Charles Silver and his colleagues studied the issue of doctor supply and found, quote, Texas was not losing physicians before House Bill 4 took effect. In a follow-up study, he and his fellow researchers concluded, quote, Physician supply was not stunted prior to reform, and it did not measurably improve after reform. This is true whether one looks at the number of patient care physicians in Texas, the number of Texas physicians in high malpractice risk specialties, or the number of physicians per capita in Texas relative to other states. Today, Texas ranks 47th in the nation in active primary care physicians per 100,000 population, and just 41st in the number of physicians overall. Rural communities remain underserved, and the state as a whole continues to suffer from a lack of health care. Texas leads the nation in the number of people without health insurance. So who are the real beneficiaries of these legal restrictions that infringe your rights? The worst wrongdoers, and the insurers who write them policies, but don't have to pay out on medical malpractice claims because tort reform bars many with legitimate cases from the courthouse. Given that a small number of doctors cause the vast majority of the malpractice, wouldn't a better approach to safety have been to focus on their misconduct? It makes no sense to broadly punish innocent patients by taking away their rights and remedies under the law. Lawmakers could have used a scalpel, but instead they used a cleaver, and Texas families are left to pick up the pieces. The tentacles of this tort reform scheme extend into the highest reaches of our courts. Jury verdicts are supposed to be respected in our civil justice system. Article 5, Section 6 of the Texas Constitution explicitly states that lower court decisions, where these cases are directly appealed, are to be, quote, conclusive on all questions of fact. But some corporatist judges on the Texas Supreme Court have interfered and overturned jury verdicts at an alarming rate. Leading law professor David Anderson at the University of Texas has observed, quote, the most controversial method of producing defendant victories is by holding that there is no evidence to support a plaintiff's verdict. The Texas Supreme Court is doing this far more frequently now than in the past, particularly in tort cases. The Texas Supreme Court should decide disputes according to established precedent, not substitute its judgment for a jury that listened closely to all of the evidence, weighed the credibility of the witnesses, and returned a reasoned verdict. Juries take their job seriously, and they do a great job of finding the facts. Baylor law professors Elizabeth Fraley and James Wren and Dean Bradley Tobin write, quote, the system is already designed to weed out non-meritorious claims. Furthermore, quote, a survey conducted of sitting district judges in Texas revealed that not only did these judges believe juries reach the right result in the majority of cases, but they believe juries award damages that are proportionate to the claimed injuries, or more frequently, damages that are lower than the judge believed the evidence warranted. Juries get to the truth, and whether a party wins or loses, juries work hard to get it right. The right of appeal is also there to correct any errors. We have checks and balances built in throughout our judiciary. There is a lot of common sense in our common law. It's important to note that juries, comprised of everyday citizens from the community, are not susceptible to the same political influence as professional politicians. You can't give political contributions to a jury. You can't fund an opponent in their next campaign. Stated plainly, they can't be bought. They can't be intimidated. And that drives irresponsible corporations bent on complete control crazy.
Next, knock the civil jury down. Whittle it down to a nub The civil jury was in the Constitution, in the Bill of Rights, in our darn Declaration of Independence. But it's annoying to big corporate powers because you can swagger your way as a big corporate power through Congress. You can go and tell the president you put money into to elect what to do. He'll put your stooges at the EPA. It's all great until you get to the civil jury, because they have an obligation, as you know, Judge Barrett, they have an obligation under the law to be fair to both parties, irrespective of their size. You can't bribe them. You're not allowed to. It's a crime to tamper with the jury. It's standard practice to tamper with Congress.
The corporate lobby groups work hard to scare everyday citizens, presenting them with a false choice that basically goes like this: you can have your job or you can have your rights. They tell you that our legal system drives up costs for businesses, making us believe that your constitutional right to trial by jury is a luxury we cannot afford. But accountability leads to safety and justice, and unaccountability leads to danger. In Texas, tort reform, which lessens accountability for unsafe corporations, has cheapened life, creating the conditions for deadly work sites. A worker dies on the job every day in our state. No one should have to choose between their paycheck and their life. In presenting this false choice between jobs and rights, the so-called tort reformers completely mischaracterize our legal system. Our laws are rules of conduct that should apply to all. They're the way we ensure people treat one another with fairness and respect. They keep us safe, and they form the backbone of an economy where people can actually compete on a level playing field, where businesses rise because they deliver goods and services better, not because they cut more corners. Rights lost aren't easily regained, which is why it is so important that we fight back against those seeking special privileges for special interests. The rule of law must apply to all equally. We must resist the corporate takeover of our courts, because true accountability through our courts keeps everyone prosperous, free, and safe.